Hello, this is Alexander Cross, Criminal Defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, don't forget to subscribe to our channel, Law Offices of Cross and Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos. So, we received an interesting inquiry here on our YouTube channel. This has to do with a hit and run from a place of an accident. Let's see here. One night, I went out with friends to a dance, and we had some drinks. My dad loaned us his car, and a friend of mine drove it. We had an accident, we ran from the place, now my father is being accused. Well, first of all, let's talk about the fact that you guys were driving, going to clubs, and you had an accident. Well, if you went out drinking, maybe you were DUI, which would be a violation of Vehicle Code Section 23152B, which is a misdemeanor that carries up to 6 months in the county jail. Now, if somebody else, other than the driver, suffered any kind of injury during the crash, even if we're talking about a little microscopic little injury, then we would be talking about a felony DUI under Vehicle Code Section 23153, which carries up to 3 years state prison, plus they could hit additional enhancements or hit you with additional enhancements if there was great bodily injury. Now, as long as everybody shut up, as long as nobody spoke to the police about any kind of alcohol whatsoever, and if there is nothing indicating that alcohol was specifically impeding your ability to safely operate the motor vehicle, then the DUI charge will basically be off the table because the DA would not be able to prove it beyond a reasonable doubt. Now let's get into the whole hit and run aspect. Hit and run is a crime. It could be charged as a misdemeanor or a felony. If anybody suffered any kind of injury during the hit and run, this would be a violation of Vehicle Code Section 20001, which carries up to 3 years state prison. If nobody suffered any kind of injury whatsoever, it's just injury to the car, damage to the car, now we're talking about a misdemeanor under Vehicle Code Section 20002, which carries up to 6 months in the county jail. Now, it's a little bit strange that your father is being charged because even though he is the owner of the car, what evidence do they have that he was driving? Now, if he spoke to the police and he said, yeah, I was driving, well then yeah, he could be charged with a hit and run, but he could have just said, no, I lent the car to my son or I lent my car to somebody else. And if there's no evidence to suggest otherwise, it's going to be very difficult for the DA to to creak through that reasonable doubt door, so to speak. In a situation like this, it's always best to remain silent. Never speak to the police at all because anything you say or do will be used against him in court. Obviously, the main thing that we're going to have to focus on, or that the DA has right now, because they have no evidence that he was driving the car, is just the fact that he was the owner of the car. Now, that alone is not enough to convict him of hit and run. Now, like I said before, if he told the police I was driving because he was trying to protect he was trying to protect you, well then that's going to be a little bit of a problem. He's going to have to retract that statement. He could theoretically be charged with lying to the police or making a false report, which would be a violation of Vehicle Code Section, Penal Code Section 148.5. But essentially, this is a situation where the DA, at the end of the day, regardless of what your father said, they're going to have some difficulty showing beyond a reasonable doubt that he was the driver. Not only this, but there's another factor to consider, which is they need to look at the chair, how the chair was configured, and how the seatbelt and chair were configured in general. Because if your father is of a certain size, and the person driving was a completely different size, and it's clearly shown that there's no way your father would have been driving the car based on the configuration of the driver's seat, well then that's going to be another basis to have the charges dismissed for your father. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices of Cross and Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos for him. But if you've been accused of a crime here in the San Francisco Bay Area and need representation, call us now for a free consultation at 1-800-862-7677. Once again, 1-800-862-7677. Criminal lawyer, criminal lawyers, DUI lawyer, DUI lawyers, criminal attorney, criminal attorneys, DUI attorney, DUI attorneys.